So I would like to say a few words about recent developments on cartel damage litigation in the Netherlands. As the President already said, the Netherlands is a very popular venue for that kind of activity. Indeed, I'm not going to dwell upon that any further, why it is so popular, but it is a fact, and we see a lot of follow-on cartel litigation. Every European Commission decision in a cartel, regarding a cartel, will lead to follow-on claims nowadays, and many of those claims end up before Dutch courts. And what we see is that in practice, the jurisdiction of Dutch courts is often not an issue, because there is almost always one of the defendants, one of the members of the cartel, which has a seat or residence in the Netherlands that allows a court to accept jurisdiction. And we also see that in practice most of the cases are brought before the Amsterdam District Court. So Amsterdam is comparable to Milan in terms of popularity, I would think. And we see that, for example, cases that are brought before courts elsewhere in the Netherlands are subsequently transferred to Amsterdam at the request of parties at both sides, because most experience is present in Amsterdam. That being said, judges in the Netherlands are entitled to sit in courts throughout the country. So it happens that if a case is brought in the south of the country, that the judge from Amsterdam will fly, in the case of the Netherlands, drive in order to sit on the bench in that case as well. And that contributes to coherence, consistency in the outcome of proceedings. Now, what I would like to say a bit more about is the mass litigation that we see in cases involving mass products and services sold to, in particular, small and medium-sized companies. And there are two big cases, and probably you're familiar with both of them. One is air cargo, which has already been going on for about 10 years, I believe, and is still nowhere, and the trucks cases. And what we see in the trucks cases is that many of these cases are brought by private, for-profit companies, claims vehicles that all operate basically on the same basis. What do? They go out into the market, say to road hauliers associations, so branch organizations of truck drivers and truck owners. They tell them, look, you have paid far too much for your truck. You paid 10,000, if not 20,000 euros too much for your trucks. You've suffered damage. You give us your claim, you have a claim. You don't need to pay anything at any point in time. We take over your claim and we're going to collect the damages for you. And once we're successful, we will pay everything to you with the deduction of a certain amount or percentage that we keep for ourselves to finance the cases. So they work on a no cure, no pay basis. And they operate on collecting all these assignments. Now, as you probably know, Dutch lawyers, Dutch advocates are not allowed to act on a no cure, no pay basis. But of course, the companies, the claim funders, can do so. So they run the economic risk, but they pay the lawyers who really act in these cases on a normal basis. What we see is that in the market there is huge competition among those claims vehicles. It's really an industry. If you have a look on the internet, you will find at least 5 to 10 of those companies, which are all competing. And what do they compete on? First of all, on the size of the damage. Not that anyone has demonstrated any damage in this case in the first place, but one says, you know, I think that the overcharge is at least 10-15%, and because it's such a long time ago, you also get extra interest, so you end up with 30% of the price of your truck. Another one is a bit more modest, says, well, it's 10% plus a little bit. But they try to inflate those percentages as much as possible. And then they compete on the withholding percentage. The lowest I've seen is 10%. In a joint publicity by a firm called Houseveld, you may have heard of them, and a Dutch road hauliers association, it is simply stated that Houseveld, very experienced, operates at a competitive percentage. It reminds me of the publicity for Rolls-Royce cars in the past, when the horsepower was stated, not the exact figure of horsepower, it stated enough, maximum speed enough. Well, this is competitive percentage, don't you worry. Anyway, they go to the media, so Dutch newspapers, the Daily News, they have an interview with a partner from one of those firms, and they believe that they act in the interest of the small companies that have suffered so much loss, etc., etc. We see that the branch organizations play an important role in this. And in the Netherlands, it's not only Dutch branch organizations. There are 3 that have brought claims or are bringing claims, but also associations from, for example, Italy or Poland or Lithuania that bring their claims to courts in the Netherlands. We have at the moment some 10 or 12 cases pending, many of them these mass claims, with assigners from over 20 jurisdictions. There's one case where over 1/3 of the claimants is from Spain, actually. But there are many others still announced, and we are waiting the outcome of the first steps in these proceedings before they will step in with their own claims. And as you may know, in the Netherlands, well, of course, that's in line with the directive, but it has always been the case like that. The statute of limitations is 5 years, but you can, under Dutch civil law, you can even interrupt the prescription of the claim by simply writing a letter stating that you want to extend the deadline. So it's very simple under Dutch law, but that's Dutch material law, so it doesn't apply to claims that are subject to a different legal system. But I come back to that, to applicable law in a moment. Now, there have been a couple of cases, judgments recently. One is from the 15th of May of this year, and it is about the duty to substantiate that is incumbent on these claims vehicles. Because what we see is that they issue a writ of summons of 50 pages, of which 30 is a copy from the commission decision and stating how bad it was, etc. And then they simply mention the names of the assigners. They say, well, these assigners have assigned their claims to us. These assigners have bought 1 or more trucks in the cartel period from 1 or more cartel members, and therefore they have suffered damage. That's about it. And based on such a rudimentary claim, they try to obtain, which is a common phenomenon in the Dutch legal system, a declaratory judgment just stating that the defendants are jointly and severally liable for the damage that they have caused to these claimants. And then after that you start follow-on proceedings on the quantification of the damages, and of course they will try to seek and negotiate a quick settlement. Now, the defendants in those cases said, well, you know, we don't even know which trucks these people have bought, from whom, when, we know nothing. Maybe these are trucks that are not covered by the cartel in the first place, like fire trucks or waste collection trucks, etc. Now, the Amsterdam District Court said, yes, indeed, a claims vehicle is just a collection of claims of individual claimants, and the same standard has to be met as for individual claimants, so you have to at least substantiate which trucks you bought, from whom, when, etc., so that we know what we're talking about. Now, that is step one in the development there. The trucks case is still in an infant stage, as you understand, but air cargo has progressed a little bit further. And there are two judgments of the 1st of May, which I would like to mention. It gives you a bit of an impression on what's going on. Now, here as well, we have these claims vehicles, and we have claims coming from all over the place. And as you know, it was a worldwide cartel, so the claims relate to flights from any jurisdiction to any jurisdiction. The claimants come from everywhere, and the defendants come from everywhere. Question is, what is the applicable law to each of those claims? Because all the assigners have, of course, they come from different countries, and different laws may apply to all these individual claims. The nationality or the location of the claims vehicle is irrelevant. It is the assigner's location that is decisive. Now, the Dutch court here took the view that all claims against all airlines by all claimants are under Dutch private international law as it applied before until the entry into force of the Rome II regulation are subject to Dutch law. And the court specifically said that it did so in the aim to ensure efficient application of the competition rules, because if all different national laws apply to all these claims, it becomes massively complicated. Question is whether this really holds water, and of course this judgment will be appealed to the Court of Appeal in Amsterdam. The district court has given leave to appeal, even though it's an interim judgment. So there is here many more years of uncertainty. But if this is the case, and Dutch law, I would say, is not unfavorable to claimants generally when it comes to Dutch substantive law, for example, when it comes to the statute of limitations, etc. If anyone who brings a cartel case before a Dutch court can claim that Dutch law applies, well, that makes life a lot easier for claimants again. But we'll see what happens. And we don't know, of course, yet what will be the approach under Rome II regulation, which is, for example, also very much relevant in connection with the truck case. But the truck cartel lasted from 1997 till 2011, so is mostly covered by the old former Dutch legal regime. We'll see what happens there. The last one I would like to mention is also in air cargo, also from the 1st of May of this year, so I just selected some very recent developments for you. And that is a question which in the context of air cargo, and those who are familiar with the case will realize that. The question is whether Article 101, the cartel prohibition, can be applied to flights to and from third countries before the entry into force of the applicable implementing EU regulation. Because the Commission only fined the air carriers for flights, intra-EU flights, but not flights to third countries. The Commission did not deal with that, and it missed the basis in Regulation 1 at the time. Now, there's old case law from the European Court of Justice, the Asjes case, dealt with by my former partner Biesheuvel in the 80s, and that related to the application of the cartel, Article 101 to the air transport sector generally, before the entry into force of specific procedural rules for the aviation sector, civil aviation sector. And the court said no. 101 cannot yet be applied, cannot be applied by national court in the absence of a kind of Regulation 17 or 1/2003 for the air transport sector. Now, based on that, the English High Court, Justice Rose, in October 2017, issued a judgment stating, indeed, Article 101, for that same reason, cannot be applied to agreements, restrictive practices affecting air transport between EU destinations and destinations in third countries. Before Regulation 1/2004 introduced procedural rules for covering those flights. And I believe that is perfectly sound, what the High Court did. But the Amsterdam District Court said, we see it differently. They had an opinion from a former judge in the General Court, Dutch judge Meij, and they disagree with the High Court and say, well, we have the direct effect of Article 101, and that's an overriding interest, and therefore we believe that 101 can be applied to those flights between European destinations and third countries. But also because this judgment is the exact opposite outcome of the High Court procedure, the Amsterdam Court decided to refer the issue to the European Court of Justice. And that is, of course, where the European Court of Justice is for, to ensure consistent interpretation of the European competition rules across all jurisdictions. The UK will be out, but nevertheless, there will be a judgment that will be relevant for the proceedings in the UK as well. All this causes further delay, so I would like to end with a note on timing. My best guess is that in air cargo we won't have any decision on the merits before 2025. Thank you very much for your attention.